ડોક્યુમેન્ટ કયા પેજ નંબર ઉપર છે? બધી રિસીપ્ટ તો
8, 6, 7 પછી 8, 9, 10, 11, 12 એ બધી રિસિપ્ટો છે સાહેબ. એક સાથે ભાડું આપતા હતા 6 મહિનાનું. અને કોર્પોરેશન હમણાં છેલ્લે નોટિસ આપી સાહેબ કે ભાઈ આ મકાન જર્જરિત છે, એટલે એ અને સોસાયટી અમને નોટિસ આપી, અમને ને માલિકને બંનેને. એ છેલ્લી સાહેબ લાસ્ટ 2 જે રજૂ કર્યા છે એમાં એ સાહેબ દાવામાં રજૂ નતા થયા, એટલે 8-5નું હિયરિંગ થયું હતું. કારણ કે એ પછી સબસિક્વન્ટલી અમને મળ્યું છે કે જર્જરિત હાલતમાં જ અમે રિપેર કરાવી દઉં. કોર્પોરેશને અમને અને મકાન માલિકને બંનેને આપ્યું છે, અને સોસાયટીએ આપી છે.
Your Honor, I have for defendant number 1. Your Honor, I am seeking liberty to submit my reply. I am submitting it.
રેકોર્ડ નતો ને એટલે એ લિસ્ટની કોપી જૂની જે આપણે કોર્ટમાં રજૂ થયેલી છે સાહેબ પાસે અહીંયા રેકોર્ડ નતો ને એટલે 2 કોપી કરી.
તમારે બીજું કેવું છે હવે?
ના સર,
Who are you?
Sir, I have for respondent number 2, original defendant number 2.
Second number?
Defendant number 2.
You are the purchaser.
Yes, I am the purchaser of the property.
From whom did you purchase?
From Mr. Sanket Chandrakant Patel.
Respondent number 1, original defendant number 1.
He was joined by way of an application moved by the plaintiff under order 6 rule 17. If I may narrate brief factual matrix for your lord's time period.
I have period because we were not present on the last date. Yes. Yes, you are the owner of the property.
I am the owner of the property.
No, now not. You are
Current owner.
subsequent owner.
He is current owner.
And you are?
I was previous owner.
Yes. What you have to say?
So, Lordship, the facts are actually that I am implemented after order 7 rule 11. Actually, my grandmother,
You were?
order 6 rule 7. Actually,
Make it order 7 rule 11 or order 6 rule 17.
order 6 rule 17. જે ઓરિજિનલી આનંદીબેન બળદેવભાઈ પટેલ, she is my grandmother. એટલે ઓરિજિનલી the disputed premises was in name of my grandfather. My grandfather died in 2008, Lordship. Then after his descendants were added, Kokilaben, Rajendrabhai, Dharmendrabhai and Chandrakantbhai in the year 2008. Chandrakantbhai is my father, Sanketbhai's father. Later on, he died in year 2016, that is 2nd of January. So by which means Sarojben, Mrunalbhai and Sanketbhai Chandrakantbhai, that I was implemented then after. So when the plaintiff didn't know at the first કે original owner કોણ છે, he is claiming that he is ભાડુઆત, he is the tenant, but actually
He is Padua.
he is the tenant of this property, but actually the case is that originally he was not aware that who is the real owner. મારા દાદા 2008માં ગુજરી ગયા, ત્યારબાદ મારા ફાધર ઓનરશિપમાં હતા અને ત્યારબાદ મારું નામ ઇમ્પ્લીટ થયું અને બધાએ 2016માં મારા તરફેણમાં હક જપ્તો કર્યો. તેમને જે પણ ભાડા પહોંચ રજૂ કરી છે થ્રુ લિસ્ટ, એમાં એક પણ મારું નામ નથી. મારી જોડે આજ દિન સુધી એમને એક પણ ભાડા કરાર કરેલ નથી. તેના માટેની એમને એક પણ રૂપિયો મને કોઈ પણ ફી કે લાયસન્સ ફીઝ અથવા રેન્ટ મને ચૂકવેલ નથી, મને અથવા પછી મારા દાદા અથવા મારા ફાધરને. એટલે આ થ્રુ આઉટ these years plaintiff has not been our tenant or any other person.
He was it is he said there was your grandfather who executed some rent receipt. You can say no, you are subsequent purchaser, so you
Originally, Lordship, if I may
then if there
reiterate, originally my grandfather was the owner. Then after through Varsai, my father and other Varsdar got included.
during the lifetime of your grandfather, the property was handed over to the plaintiff and one of his cousin brother or uncle on rent.
No, Lordship, we had
There
not.
are rent receipt. First listen. There are rent receipt by which your grandfather has accepted the rent, meaning thereby there was some sort of understanding between them with regard to giving your property on rent. Otherwise, it would be an illegal possession, but you have continued to accept the rent. And thereafter, subsequently, when your grandfather passed away, thereafter for some time, the rent was accepted, and thereafter you have stopped accepting the rent. It is not mere leave and license, that would be a subsequent, because
Lordship,
the rent receipt are of 1998, 1999. His name is shown as an occupier in the suit property by virtue of the corporation receipts.
pardon?
His name is reflected as an occupier in the notices which are given and tax receipt by the Ahmedabad Municipal Corporation.
On that
In this
matter,
regard, you can say.
on that matter, if I can highlight, some Hargovan Bechardas name is there, while plaintiff's name or his father's name is never on the record. Firstly, secondly, only photocopies have been attached therewith. No original rent receipts are attached.
That
I would like to highlight third point, Your Honor, that he had claimed in the plaint that he was owner from 2000, or I guess
He has not.
he was the tenant from 2000. My mistake. He was tenant from 2000, while there are certain rent receipts which are from year 1999 and even 1982. So how does that come on the record? And these are mere secondary evidences, Your Honor. It is possible that he might have purchased it.
Time of injunction application, Xerox document would be submitted. Therefore, now it is not the case whether it is primary evidence or secondary evidence.
Your Honor.
It is the court has to form prima facie opinion, whether injunction is to be granted or not. The moment you say that there are rent receipt of the year 1982 also, the property becomes a rented property.
That is what I am saying, Your Honor. We have not issued those rent receipts. Neither my grandfather or any other family member has even signed those rent receipts. For that matter, I may issue a criminal proceedings against them for forgery, Lordship.
Then
Because-
you may initiate. But now.
Because if he is very sure that he has received the rent receipts, then where are the original rent receipts? Even,
If you-
even for the subject matter, when he has filed the appeal, why he has not produced those on record? Because he is not
Filed
possessing
today.
those.
It is filed today.
Lordship, we have not received it.
Then do.
That all that documents is
Original-
the original.
No,
That
because-
copy was there.
Because
With them.
we have also written that in our written statement that only photocopies are given.
Photocopies would be given. There is the question of providing original at this stage.
But even if we see that the Praman Patra of Kalinagar Palika, then also name of Hargovan Bechardas is written.
So if
And
we-
his name
if
is
we go
nowhere
by-
stated.
If we go by every year submission, it would prima facie reveals that the property at some point of time was given on rent, for which rent receipts were being
My
issued
I apologize. My
merely-
submissions are that he has just
merely by saying that rent receipt are not given by my grandfather or anyone. That would not be okay. You will be launching a criminal prosecution that you may do. But since 2020, the suit has been filed. There is no criminal prosecution. Neither your grandfather during his lifetime has ever filed any criminal complaint.
But
In
that
any case, the notices are given by the corporation to the occupier of the suit property, meaning thereby someone is there in the suit property.
my apologies. I am just trying to put down that my humble submissions are that there were no tenants as such, and he has produced the fake receipts and the fake documents on record.
Yes. Now, where is your written statement? You filed written statement. Where is that? What is the exhibit? I don't know.
એ 47 છે સાહેબ 47 એમણે જે exhibit 47 લખ્યું છે.
Thank you. Lordship, these are my humble submissions. That I was the original owner, neither I have received any rent, nor have I issued. So even if we consider that my grandfather, if for instance, if we consider, then also he has not paid me a single rent. There is no single receipt which is signed by me, Sanket Chandrakant Bhai Patel, from 2016 to 2020. So there is nothing on as such which is on record, which proves that he is a tenant. In my respectful submissions, these rent receipts and the Praman Patra all are forged, and we have not received any copy as such that original records are placed before my lords.
It can be before the trial court. It would be at the time of submitting the original documents. Right now, it will be Xerox copy only. Even if you file a suit, then you would be submitting the Xerox copy only at the time of interim injunction application.
Lordship, it is very easy these days to get a bill book and get it printed and easily place it on record, just to prove that they are the tenants of this such a marvelous property which is disputed. Because
Marvelous property.
exactly, because they
It's
just
in
have to pay
dilapidated
250
condition.
rupees. That is what their plain suggest. That they have just been paying 250 rupees. Not a single penny or a single rupee I have received till date. Not even today.
It is, he said that you are not accepting because you want the property and you have already sold it.
Lordship, I was the rightful owner. I have already sold it to the respondent number 2.
At what price?
So my ownership was not a matter of dispute, Lordship.
Your ownership is not in dispute. Therefore, he is tenant. Your ownership, there is no dispute.
But as a owner, I have never received a single rupee as a rent. There
Your
was no rent agreement signed by me. Even my grandfather had not signed a single rent agreement. There is not any rent agreement is not produced before your lords in the name of Mr. Baldev Bhai Patel as well, in the name of Anandiben Patel, or in the name of any of the Warasdar which I have claimed right now, Lordship. Is there any rent agreement? That is what my question is to learned advocate.
There is no rent agreement. That you are right.
No rent agreement, no rent receipt has been signed. Even I would like to point out just one thing. In one rent receipt, Mr. Baldev Bhai has signed in Gujarati. In another rent receipt, he has signed in English. I assume that in bank, I would be signing a single particular signature, and I will be using maybe it may be possible that I may be using any other signature in my
A
rent
smart
receipt.
person would make signature in different language and with even different signs,
But
so that it may not.
Lordship, there is no consistency. That is what my submission is.
But
Right?
from 1999, why rent receipt was issued? there?
Exactly. Even if they are claiming that they are tenants from 2000, then how they have come up with the rent receipt in year 1999 and 1982 as well?
So your grandfather would have given it on rent.
Lordship, they have made the submission in the plaint that they are tenant from 2000
Yeah.
onwards. So how they have placed on record the receipt of year 1999? So that is again a big question. So they have just placed some forged documents which they may have accumulated. કોઈ બીજાની પણ હોઈ શકે છે બિલ બુક.
તમે ક્યારે દસ્તાવેજ કરી આપ્યો એમને?
2020.
2020 માં.
I would point out exact date. Exact date. 27th of February 2020.
તમે એમને વેચી દીધો.
To respondent number 2, original defendant number 2.
તો પછી corporate
અમારી આર્ગ્યુમેન્ટ પર સાહેબ આપ સાંભળી લો પછી જે રિબટ એમનો.
Regarding this self deed, that
Lordship, he has already pointed out we were unable to
I'm just
narrate our
showing
case.
tenements number સાહેબ એમાં છે બસ that is what I'm saying. બસ બીજું કંઈ.
તો પછી કોર્પોરેશન નોટિસ ઓક્યુપાયર તરીકે એમને કેમ આપે છે? તમે જો વેચાણ 2020 માં કરી દીધી હોય એમને તો પ્રોપર્ટી એમના નામે થઈ જવી જોઈએ ને. પ્રોપર્ટી એમના નામે થઈ જવી જોઈએ. દુકાનની કન્ડિશન કેવી છે?
Lordship, I think he is right now present, so he might be able to narrate it in a better way. Original defendant.
તમે
number
કેવી કન્ડિશનમાં વેચી હતી?
2. Lordship, અમે તો as it is જે અમારી
કેવી એટલે ચાલુ હતી, બંધ હતી, પડી ભાંગી એવી હતી, જૂની
ના
પ્રોપર્ટી
એ
છે?
ફેરી કોરોના કાળ હતો એકચ્યુઅલી અને
તમે ગયા છો ને, તમારી પ્રોપર્ટી છે તો
Lordship,
તમે તમારી પ્રોપર્ટી જોવા તો ગયા છો ને? તો કેવી કન્ડિશનમાં હતી તે?
ત્યારે બંધ જ હતી. જે ફેરી અમે વેચ્યું ત્યારે કોઈ દુકાન ઓપરેશનમાં નથી.
એટલે કોર્પોરેશનની નોટિસ ઉપરથી તો એવું લાગે કે પડી ભાંગવાની તૈયારીમાં હશે પ્રોપર્ટી.
Exactly.
હવે
That is my,
now he has come to possession is there but not lawful.
not law.
But-
In my respective submission. Now, if I would draw further attention of this honorable court, what has happened is, in their suit, from 2002, they are claiming tenancy rights over the property. But how that right has been derived, it is nowhere stated now. That is very surprising thing, that as far as their case is concerned, their very case is we are having possession since 2002. Now they are having certain documents in the name of Hargovan Bechar Das, સાહેબ appeal from order માં this honorable court is being misled by one statement કે મારા father છે. I would first like to draw your lordship's humble attention to that appeal from orders one statement which says that હરગોવન બેચરદાસ મારા father છે સાહેબ. હાલના વાદીનું નામ રસિકલાલ ડાયાભાઈ વાળંદ છે. તો ડાયાભાઈ એલિયાસ હરગોવન બેચરદાસ છે એવું એમને સાબિત કરવું પડે. That is not their case સાહેબ. એટલે એમના father પાસે આ પ્રોપર્ટી હતી અને પછી એમની પાસે આવી એવો કોઈ કેસ નથી. If I may draw my lordship's humble attention to appeal from order F 2F, just for a while. How the court is being misled, that is very important to be noted.
તમે એને ઇલીગલ ડિસ્પોઝ કરવા માંગો છો?
Sir, મારો કેસ completely different છે. પેલા તો એ tenant નથી, that is my case. First,
Suppose if he is in possession.
he is in possession.
Suppose, for example, we are not admitting your anything.
Right.
But suppose if he is in possession, then how are you going to vacate him?
No, firstly, they have filed this frivolous litigation.
Suppose we.
After getting
Forget, his suit is rejected.
then I am having all the rights to evict them
Then how you are going
with
to?
eviction proceedings. With eviction proceedings, my પાસે land grabbing no પણ option available છે. I can very well go before the authority.
Engraving subsidy, that's a different word for you.
Right.
You are, I think, civil dispute, you both are giving criminal threats.
We are not. સાહેબ હવે helpless શું છે આમાં
No, no,
માણસ
you are
પૈસા
right.
ખર્ચીને property ખરીદીને feeling helpless since 2020 અને એ લોકો કહે છે એમ 2016.
See,
So
you,
one person is having the possession of
You
the
purchase
property
the
since 10
property.
years without paying a single rent.
since 2020, there is no complaint, no FIR about forgery or fraud documents. But
સાહેબ મેં 155 ના contentions લીધેલા છે ને
Second-
સાહેબનું ધ્યાન દોરવાનું.
Secondly, land grabbing would be available to you at the relevant time, not now. You are the purchaser of the property.
Right.
So there is a principle of caveat emptor. A buyer has to be vigilant
Right.
and he has to verify the title, possession of the suit property. So land grabbing would come into picture when you are the lawful owner and someone has grabbed your land.
My
Now,
lord,
prior to your becoming the owner, it is his case that he was already a tenant there. Maybe there might be number of lacunas, even in the suit, even in the nature of evidence that has come, and coupled with the fact that there is order of the trial court. But now,
this is a suit in my respectful submission is to perpetuate the possession which is not lawful.
that is another thing I am telling you, that there are many things which would be going against him. His suit is not under the rent tax. That is the first.
Yes, that is the first.
That is the first, even if
They
you
have
stay or
taken
not.
that specific contention, though in appeal from order again to mislead this.
His suit is not under the rent tax. So that
Yes.
would be a first hurdle he would have to overcome.
They are saying that we
Now-
are protected and under.
Now, how are you going to vacate? Suppose if he is in illegal possession, then also what would be the remedy available to you?
Eviction proceedings.
So without that, till that you get that eviction, you won't be able to.
My lord, even otherwise, I am not going to vacate him without lawful process. But that does not mean that they are entitled for injunction against me, though I am having all the rights in my favor. That is
Yes,
my
ચાલો,
respectful
તમારું શું
submission.
કહેવું છે?
Sir, મને ખાલી 5 minutes આપવામાં આવે. I would like to draw what is my case. કારણ કે otherwise so I am having all the rights of the property and then after their possession is being perpetuated for no
That
reason.
would be the subject matter of trial, what right you are having. Today, you are the, as
I
per
know
your
the prima
submission,
facie case will be.
you, as on day today, you have purchased the property from defendant number 1.
Yes,
That is the case.
yes.
Now, what is the nature of property? You have purchased the property as it is. It might be having a tenant, it might not be having a tenant, it might be having clear title, it might not be having clear title. With whatever condition that has been accepted by you.
Right.
That is all, that's all.
અમને શાહ ખાલીનો પ્રત્યક્ષ કબજો લખીને દસ્તાવેજમાં આપેલો છે સાહેબ. In addition to that 2016 they are not paying rent એ evident વસ્તુ છે on the record છે.
That is also one more disputed fact. As per his submission, he is saying, yes, I went to give them, they are not
તો સાહેબ
accepting.
મની ઓર્ડર કરે, બેંકમાં જમા કરાવે, કોર્ટનો ઓર્ડર લઈને કોર્ટમાં
I
જમા
know
કરાવે.
your case is that they are not paying rent to you.
પણ એમણે પ્રયત્ન કર્યો છે whether they have shown anything on record કે they have attempted and thereafter got refusal. Their attempt is not there on record. એક પણ attempt બતાવે સાહેબ 250 રૂપિયાના નામે ખોટી ભાડા પહોંચો જનરેટ કરી સાહેબ બધી ભાડા પહોંચોનો ખાલી ચિતાર આપું ને તમને તો સિમ્પલ સેન્સમાં ભાડા પહોંચો એટલી અનસર્ટેન રીતે બનાવવામાં આવેલી છે કેટલાકમાં નામ છે કેટલાકમાં નથી કેટલાકમાં સહી છે કેટલાકમાં નથી ઇંગ્લિશ સહી છે ગુજરાતી સહી છે ભાડા પહોંચોમાં ક્યાંક હરગોવન બેચરદાસનું નામ છે જેની સાથેનો રિલેશન દે આર નોટ એબલ ટુ એસ્ટાબ્લિશ કાળી નગરપાલિકાની જે એન્ટ્રી પેલી સંસ્થાની નોંધણીના પ્રમાણપત્રની વચ્ચે
Where Kali Nagar Palika is situated, you know, the area?
સાબરમતી કાળીનગર.
Kali. So now it would be known as Sabarmati. At relevant point of time, it would
But
be
sir,
Kali Nagar
they are
Palika.
relying upon this is their case. Therefore, I am.
Now we would not be even, I have not heard Kali Nagar Palika was in Ahmedabad. Only when I went through this rent receipt, I came to know that there is some area like Kali Nagar
It
Palika.
is easy and it is easy to forge and fabricate everything. When there is no existence, व्यक्ति no existence, Nadi Nagar
Now
Palika
whether it is forged or not, then your seller's grandfather would be required
they
to
are
pay.
having the rights. They are having the rights.
They can't say because now they would be happy. They have sold it to you.
They are contented. સાહેબ તો આમાં પૂછણીમાં જોડાયેલી 617
They
તે declaration ની કે pleadings નથી એમને જોડી દેવામાં આવ્યા છે 617 પછી
the original suit was against you.
No, original suit was against me as well as one other person, આનંદીબેન બળદેવભાઈ પટેલ.
જે મારા ગ્રેન્ડ મધર હતા અને એમને એ પણ નથી ખબર કે 2016 થી 2020 સુધી તો હું ઓનર હતું. ઇફ he is saying કે રેન્ટ એમને આપ્યું છે અને રિફ્યુઝ કરવામાં આવ્યું છે તો સંકેતભાઈ કોણ હતા શું હતું ઓનર હતા he didn't know. એવું કઈ તો પોસિબલ સાહેબ એ લોકો આવતા રેન્ટ આપવા માટે તો એમને જાણ હોત ને કે ઓરિજિનલ ઓનર કોણ
સંકેતભાઈ
છે.
દીકરા ને તમારા સંકેતભાઈ તમારા ફાધર થાય.
I am Sanket.
You are Sanket.
I am Sanket. My grandmother is Anandiben. Original owner, my grandfather, Baldevbhai.
પછી એમને તમને કઈ રીતે આપી પ્રોપર્ટી?
બળદેવભાઈ મારા ગ્રેન્ડફાધર હતા ત્યાંથી એમની ડેથ થઈ 2008માં 2008 પછી 4 વારસદાર એડ થયા તેમાં મારા ફાધર હતા ચંદ્રકાંતભાઈ. ચંદ્રકાંતભાઈ ના અવસાન પછી મારું અને બીજા 2 વારસદારનું નામ એડ કરવામાં આવ્યું અને દરેક જે બાકીના જે હતા અંદર તેમને મારા ઓનર્સે મારા તરફેણમાં હક જતો કર્યો. This is how I became in 2016. But then after also આટલા બધા ઓનર્સ બદલાઈ ગયા આટલા બધા ઓનર્સ હતા એક પણ ની સહી નથી. બળદેવભાઈ એમના ધ્યાનમાં પડ્યું એટલે બળદેવભાઈની જ સહીઓ છે કે છેક સુધી.
ત્યારે પછી see the nature of human being would be કે ફાધર ગ્રાન્ડફાધર હતા ત્યારે સુધી રિસીપ્ટ લેવાતી હતી પછી જેવી પ્રોપર્ટી ટર્ન થઈ કારણ કે ખાલી તો કરાવી ન શકે રેન્ટ એક્ટ લાગુ પડે એટલે
સાહેબ એ લોકો હતા જ નહીં.
લાગુ ક્યારે પડે કે જ્યારે રેન્ટ રિસીટ રેન્ટ નોટ અને રેન્ટ એગ્રીમેન્ટ કંઈક તો હોવું જોઈએ ને સાહેબ. How they came into possession that is not established. How they are retaining possession not established. એ પણ lawful નથી અત્યારે છે એ પણ lawful નથી તો સાહેબ how would they bridge this gap in between and would apply rent act directly to my case.
તમારો તો કેસ જ નથી તમે તો પરચેઝર છો એટલે તમારી યારે તો એ રેન્ટ એક્ટ છે જ ને તમને જોઈડા જ ખોટા છે રેન્ટના દાવામાં.
And I am facing today this litigation and they are perpetuating this possession by way of this suit proceedings and injunction proceedings.
અને તમે જે પોઝેશન લીધું either you have knowingly accepted
સાહેબ
અને otherwise કોવિડમાં માણસ દુકાન જોવા તો જાય જ ને માસ્ક બાંધી.
બધું બંધ હતું ને એ વખતે આ લોકોએ જ્યારે પ્રોપર્ટી સેલ ઓફ કરી ત્યારે they have written in my sale deed કે ભાઈ શાંત ખાદી અને પ્રત્યક્ષ કબજો સોંપેલો છે.
સાહેબ આ વસ્તુ બે રિસ્પોન્સ
કરવા ભાડુઆત હોય તો એમ કહે કે ભાઈ અમારે ડિસ્પ્યુટેડ ભાડુઆત છે એવું તો કોઈ કહે જ
I am
નહીં.
bona fide purchase in that sense.
સાહેબ એક વસ્તુ હાઇલાઇટ કરીશ આપના
For bona fide purchaser also you have to verify the title. Have you verified it? For second, have you verified the property? Where is the property? Seller might say anything, but you have to go to the
Sir, whether that benefit should be given to them, that is the
see.
question.
Suppose
to
in this
myself.
question, in this bank grants a loan in a property which is already occupied by a tenant. There might be dispute between the tenant and the landlord. Now bank grants loan. Then the original owner defaults in paying the loan. It becomes NPA account and then surface proceeding and bank take away the possession. So by invoking surface by the bank, would the right of a lawful tenant would get vanished? No.
Sir, lawful tenants तो साबित करें whether they are tenants.
Because it was the duty of the bank to ensure that prior to giving loan, they have to verify the title, they have to verify the occupation, they have to verify the possession. If that is satisfied, then only then, otherwise property will go with tenant, tenant and tenant. That is settled position.
My lord, in my respectful submission, if such a ratio would be considered, then what will happen is they will try to perpetuate this forever, forever.
No,
I will have to fight forever. They will fight forever.
it is only in
And they
the,
are enjoying the possession without
it is only in the
pay
case
any
of
single
lawful.
penny.
It is only in the case of lawful tenant.
They are unlawful tenants.
That
is
would
my
be different.
submission, my lord. They, even today, if my lord would pose a question to them, on what basis you are occupying this property today? અને સાહેબ એમની રેન્ટની જ એમની ખુદની રેન્ટ રિસીપ્ટ જે એમણે રજૂ કરી જેમાં સ્પષ્ટ લખ્યું છે ભાડું દર માસે નિયમિત આપવાનું રહેશે.
They recorded, but the recording officer is no more, and those statement could not actually proved. It has been produced on record, sir.
It is proved or it is merely exhibited.
Not proved and not exhibited, sir.
These statements are not proved and not exhibited.
Yes, sir.
13 statement are proved and exhibited.
Exhibited, sir.
And there is no explanation of the incriminating circumstances against the accused.
Yes, sir. And the aspect of making his wife partner in the wealth fund, receiving the money, and the money transferred to his bank account, and purchasing the land, and as well as making the payment to the group finance for the purpose of clearing his debt, has been admitted by him, sir. Now, first statement, if you look,
The argument was that these statements are admissible.
these statements are admissible.
On what basis?
Yes, sir, that I will point. That and three aspects, sir. Statements are admissible, that I am coming, and two other aspects, sir. So far as rebuttal portion is concerned, no evidence has been laid by him in his defense to rebut the evidence. And thirdly, sir, in his even further statement, he has not stated anything regarding this, sir. Now, sir, so far as the judgment of Section 50 का क्या है? नहीं, इसको समझाओ, why it is admissible. એટલે સાહેબ actually in the judgment in 1997 Supreme Court judgment,
I want TMLA judgments only.
yes,
The
it is
statement
also
of section
the
50.
reference of section 50 statement is there in the judgment of Vijay Madan Lal, sir. It is also there, sir.
Now, under which provision that would be admissible from the PMLA?
No, section 50, if you look into the section 50, sir, the authorized officer who record the statement power of authorized authorities regarding summons, production of document, and to give evidence. The director shall, for the purpose of section 13, have the same power as are vested in the civil court under the Code of Civil Procedure 1908, while trying a suit in respect of the following matters, namely, discovery and inspection, enforcing the attendance of any person, including any officer, reporting entirely entity and examining him on oath, compelling the production of record, receiving the evidence on affidavit, issuing commission for examining of the witnesses and documents and any other matter which may be prescribed. The director additional director, joint director, deputy director or the assistant director shall have power to summon any person whose attendance he considers necessary while to give evidence or to produce any record during the course of any investigation or proceeding under this act. All the persons who summoned shall be bound to attend in person or through authorized agent as such officer may direct, and shall be bound to state the truth. That is important. State the truth upon any subject respecting which they are examined, or making statement and produce such document as may be required. Even producing proceedings under subsection 2 and 3 shall be deemed to be a judicial proceedings within the meaning of section 193 and 228, subject to any rules made in this behalf by the central government. Any officer referred to in subsection 2 may impose and retain in his custody for the such period as he thinks fit any records produced before him in any proceeding under this act, provided that an assistant director, deputy director shall not impound any record without recording the essence in it, retain in his custody any such record for a period exceeding 3 months without obtaining the previous approval of the joint director. હવે સાહેબ સેક્શન 50 આપણે જોઈએ તો it has been considered the power are confirmed in the officer like civil court, sir. If he is recording the proceeding in a civil court. And thirdly, sir, plus 3 જોઈએ આપણે so he is supposed to speak the truth. And thirdly, sir, fourth, these proceedings are considered as judicial proceeding, and if he does not disclose the true fact or give the false statement, then is liable for the prosecution under section 193.
Where it says that it is a judicial.
Judicial proceeding.
Where, how can you?
It is beginning of the first the director shall, for the purpose of section 13, have the same power as are vested in civil court under the code of civil procedure, while trying a suit in respect of following matters, namely.
The powers are being given.
Yes, sir.
For what purpose? It is for discovery and inspection. He may enforce the attendance.
Yes, sir.
of any purpose.
એટલે સમન્સ કાઢવાની બધી
Now
procedure.
it can't be read that it is judicial proceeding.
Now, sir, if you come to paragraph 3, sir, subclause 3, sir, all the persons who summoned shall be bound to attend a person or through authorized agent as such officer may direct and shall be bound to state the truth upon any subject respecting which they are examined or make statement and produce a document as may be. This is a compulsory for the witness or the accused to speak truth. And એના પછી સાહેબ every proceeding under subsection 2 and 3 shall be a judicial proceeding within the meaning of section 193 and 220.
So it is only for the purpose of 193 and 228.
He is
With
liable.
regard to giving false evidence.
Yes. He is liable for the perjury, sir.
And it is only for the purpose of this.
Yes,
Section 50 for the purpose of investigation.
Yes, sir.
It is judicial proceeding.
Yes, sir.
It does not say okay, whatever he does, everything is judicial proceeding.
No, I am not that point. I am just.
I would get statement under section 50 is there.
Yes, sir. Yes, sir.
Now, can you point out from any
Yes,
case law?
there are the analogy. So relevancy of the statement recorded in section 50 is at the proviso of section 50 and section 108 of the Customs Act are para-materials act. And 1997, Supreme Court larger benches delivered a judgment, sir. The statement of the accused recorded under section 108 is admissible in evidence. It's a substantive piece of evidence. That is another judgment of Naresh Sukhmani. In that judgment, it has been held that that statement is admissible and that can be the sole basis of conviction, though prudence required for the corroboration.
Point out from the PML. I will consider, but if you have anything on the basis of PMLA, so it is.
મદન મદનલાલ જૈનના જજમેન્ટમાં પણ સાહેબ 26માં સાહેબ આ ડિસ્કસ કરેલું છે સાહેબ.
What is that?
We would now elaborate upon the meaning of investigation in clause NA of section 2 subclause 1. It includes all proceeding under the act conducted by the director or an authority authorized by central government under this act or collection of evidence.
કયો પેરેગ્રાફ છે?
26.
એમાં મને ખાલી એટલું વાંચી દો કે it is admissible in evidence.
Yes, sir.
So you are reading it right now in the court. You point out, you can say again, para 26, there it is written.
હા એ જોયું છે.
પણ એ બધું જોઈ ના હોય.
નહીં, હું એકચ્યુઅલી આઈ વોઝ ઓન ધ ફેક્ચ્યુઅલ આસ્પેક્ટ અને જે નોટ તૈયાર કરી એમાં પણ એના ડિસ્ક્રિપ્શન તો લખેલું છે કે વાય ઇટ ઇઝ એડમિસિબલ છે.
તો એમાંથી કયો ને.
આમાં સાહેબ એકચ્યુઅલી PMLA નું જજમેન્ટ આ મદનલાલ જૈનમાં મદનલાલ ચૌધરીમાં ડિસ્કસ કર્યું છે, પણ એ સિવાય સાહેબ અધરવાઇઝ છે એ તો હું બતાવું સાહેબ.
જે કહેતા હોય એ બતાવો ને પેલા, પછી બીજા રસ્તો કામ લઈ જાવ છો. અને એમાં ન હોય તો પછી મને કયો તો ફેક્ચ્યુઅલી ચાલુ છે.
હા, હું એટલે ફેક્ચ્યુઅલ કહું છું, કહું આપું છું. પણ બેઝિક સાહેબ ક્રાઇટેરિયા એ છે કે there are
બેઝિક તો મને બધું થાય સ્ટેટમેન્ટ માં.
નહીં, નહીં.
ગોસ્વામી સાહેબ કે આને અડાય જ નહીં. અલ્ટિમેટલી ઇટ સ્ટેટમેન્ટ.
ના ના, એટલે હું એનો
અંડર એરેસ્ટ
વેરિયસ જજમેન્ટ સુપ્રીમ કોર્ટે given
PMLA નું જજમેન્ટ.
PMLA નું બતાવું સાહેબ.
સેક્શન 50 નું સ્ટેટમેન્ટ એડમિસિબલ છે, વાત પતી ગઈ.
હા, એ તો છે જ ને. એ બતાવી દઉં સાહેબ.
કસ્ટમમાં કીધું, નોમાં કીધું.
એના પાછળનો ક્રાઇટેરિયા સાહેબ શું?
Statement ultimately it has been held care. Now it has to pass to the customer. It is NDPS ના ઓફિસર એ સેમ છે. If you are telling by customer.
યસ સર.
So we don't know.
એ પેલું જજમેન્ટ હમણાં છેલ્લે આવ્યું,
આ છેલ્લે આવ્યું.
લાર્જર બેંકમાં આવ્યું.
There also custom act judgment is considered. So when you are making submission કે પેરીમેટેરિયલ પ્રોવિઝન આમાં છે તો સેક્શન 67 NDPS માં પેરીમેટેરિયલ પ્રોવિઝન છે.
નહીં, 67 આખું પ્રોવિઝન જુદું છે. એમાં વર્ડ હેઝ બીન યુઝ
ઓફિસર
સિમ્પલી રેકોર્ડિંગ ધ સ્ટેટમેન્ટ. આમાં તો હી ઇઝ સપોઝ ટુ સ્પીક ધ ટ્રુથ. અને બીજી વસ્તુ સાહેબ કે એને 67 નો ડિસ્કાર્ડ એટલા માટે કર્યો કે DRA officers are given certain powers of police officer. And once the officer has been given the powers of
given the power to arrest
yes,
your ED officer.
yes,
Now which is that power? It is power of police to arrest the accused.
that is
Similar power.
નહીં.
You are also given the
Sir,
power to summon any person.
NDPS, yes sir,
You are given power to summon anyone.
yes,
NDPS also power is
Yes.
given to summon. Now take a case of police officer on the basis of FIR. He also issue summons. He inquire, and if he finds he arrest,
but
same
આમાં
power are given. So that is already been discussed in this by Justice Nariman.
નહીં, હમણાં જે લાર્જર બેંકનું છેલ્લું જજમેન્ટ જે આવ્યું એમાં 67 જે ડિસ્કાર્ડ કર્યો એમાં રિઝન્સમાં એવું લખ્યું છે કે સિન્સ ધ DRA officers are given specifically given power under section 52, he can exercise the power of police officer. And once the officer is alert with the police officer, then statement recorded by him is not admissible. એવું ઓલ્ડ થયું સાહેબ એમાં. અને જસ્ટિસ ભાનુમતી has actually differed she is the third judge, sir.
Yeah, yes.
Yes, sir. એટલે criteria is this, that since the officers of customs, PMLA, DRI are not the police officer, their statement is admissible in evidence. Why police officer statement is not admissible? Section 161 and 162 આપણે જોઈએ CRPC 161 માં ખાલી recording of the statement છે અને use of the statement has been prescribed in section 162 that can be used for a limited person. And police statement before police officer is 24. 24 comes in the way. But
CRPC લાગુ નથી પડતી આમાં.
evidence act ની section 24.
CRPC લાગુ પડશે ને PMLA માં બી.
હા લાગશે ને.
Therefore, section 154 CRPC ના પાવર પણ લાગુ કરી શકાય ને આમાં.
154 નહીં લાગે એમાં પણ જજમેન્ટ છે સાહેબ.
156 છે.
154 is not applicable.
I think the powers of police officer. આવી આર્ગ્યુમેન્ટ આવી શકે એમ.
નહીં પણ એમાં તો કેટેગરીકલી સાહેબ જજમેન્ટ છે. There are 3 judgments કે these officers are not police officer. સૌથી પહેલું જજમેન્ટ દીપક
મને બતાવો કે PMLA નો ઓફિસર ED નો ઓફિસર he is not a police officer. Matter ends.
172. આમાં સાહેબ 172 of the Madanlal judgment, sir. In other words, there is stark distinction between the scheme of the NDPS Act deal with by this court in Tufan Singh and that in the provision of section of 2002 Act under consideration. Thus, it must follow that the authorities in the 2002 Act are not police officers. Act consequently, the statement recorded by authorities under 2002 Act of persons involved in the commission of the offence of money laundering or the witnesses of the for the purpose of inquiry investigation cannot be hid by the vice of Article 20 subclause 3 of the Constitution, or for that matter Article 21 being procedure established by law in a given case, whether the protection given to the accused who is being prosecuted for the offence of money laundering.
ચાલો કઈ તમે બીજું કર તમારા રિટન આર્ગ્યુમેન્ટ્સ માં આપજો.
હું આપી દઉં સાહેબ. એટલે સાહેબ પહેલું સ્ટેટમેન્ટ જે રેકોર્ડ કર્યું એનું that was recorded by Exhibit 45, sir, on 10th January 2013, sir. And that is a sort of formal statement, sir. But એમાં એની પ્રોપર્ટીના ડિસ્ક્રિપ્શન એમને આપ્યા આન્સર 4માં. 3માં કીધું what is your and your family's source of income. પછી 4માં do you have any other property? In the year 2008, state government of Gujarat under this scheme for providing housing plots to government officers had allotted 250 square meter plot to me for a total cost of 2.16 lakh. I have availed a loan from Group Finance and constructed a house on the same. I reside on the property of as of now. I have agricultural land at measuring 1.75 crore. This plot was gifted by my father in 2002. The land is located in village called Nana Mowara, Dehgaon district, Ahmedabad. Subsequently, additional 1.6 crore, 1.6 acre of land was purchased in 2008 in the name of my wife and children. It is pertinent to note here that my wife belongs to Dehgaon and land was purchased from family members. I will produce the purchase document and source of fund with the 15 days time I have to get it from the government. પછી 134 વૃંદાવન બંગલોઝમાં જે એમનો બંગલો છે that was of his father, sir. અને ફાધર એમને વિલથી આપેલો. પ્રાપ્તિમાં હજી દાખલ નથી થયો. ATS માં દાખલ થઈ ગયો છે આપણે. ફાઇલિંગ નંબર
Yes.
હા એટલે this is a formal type of statement. એમાં એમને એમનું ગવર્મેન્ટના ડોક્યુમેન્ટ રજૂ કર્યા. પછી એના પછી સર જે સ્ટેટમેન્ટ રેકોર્ડ કર્યું that was recorded on 27 June 13 sir by AP Sharma, assistant director. It has not been exhibited since the officer has been passed away sir. Then next statement was recorded on 18/9/2013 sir by PP Sharma. And no, sir.
You can do one thing, whatever statement are recorded. And you make a note in your argument. Okay, this is relevant for this purpose.
Yes sir. એ જે બનાવી દઈએ છે. એટલે એ નોટ બનાવી એટલે ટેબલ બનાવીને આપો
Table
sir.
બનાવી.
Yes,
For
sir.
this purpose, it is relevant.
Yes sir. What is his admission and what is the purpose and
Yes.
in whose evidence these statements have been produced and proved. Important statement જે છે સાહેબ એના પછીનું exhibit 59 sir.
Statement.
Statement which was recorded on 29/2014 sir.
29.
12 September 2014. 12/9/14
Yes.
એ સ્ટેટમેન્ટમાં સાહેબ એમના એકાઉન્ટની બેંકના એકાઉન્ટના ડિસ્કશન એમને એક્સપ્લેનેશન આપ્યા છે કે આ એકાઉન્ટમાં એટલે એડમિશન્સ છે બધા એમના અને ઇટ હેઝ બીન એકચ્યુઅલી કોરોબોરેટેડ વિથ ધ ડોક્યુમેન્ટ એવિડન્સ ઓલ્સો સર ઓલ ધ સ્ટેટમેન્ટ બાય વે ઓફ પ્રોડક્શન ઓફ ધ બેંક એકાઉન્ટ ટુ ધ બેંક ઓફિસર્સ. Second page ઉપર સાહેબ.
Yes, you can read.
Yes, sir. In the subject statement of bank account with Kotak Mahindra Bank, there is credit entry of 2,90,000 on 15/10/2008 and 4,50,000 on 16/4/2012. Please explain the source of the same. I have seen the same and have signed in token of having seen. I say that the credit of 2,50,000 on 16/4/2012 by RTGS was transferred from my wife's account with Bank of India. Regarding another credit account, 2,90,000 on 15/10/2008, I say that this credit received from my Bank of India account number so and so. Actually, next question. You are being shown the bank account statement of NRO account in the name of Shamal Sharma with Bank of India Please explain the credit and debit entries in the said account. I have seen the subject account statement and have signed the same in token of having seen. I say that there are two debit entries on 8 in my name. In this regard, I state that 4,50,000 was transferred through RTGS in my Kotak Mahindra Bank account as stated by me in my earlier statement. Rupees 5 lakhs has been received in my Bank of India account. Please explain other debit and credit entries in subject NRO account with Bank of India. In this regard, I have to submit that debit entries dated 24 October 2008 for 2,85,000 is for the payments to Sri Tushar Rawal for the purchase of 0.71 hectare of agricultural land in my name. I would like to add that Srimati Shamal Sharma, that is my wife, belongs to Dehgaon from her mother's side, and Sri Tushar Rawal is her first cousin, and deal was effected at the instance of my wife in my name, as she could not present herself in the name India at the material time. As regard to other credit and debit entries, only my wife can throw light. એટલે આ લેન્ડ જે લીધી એના વાઇફના પૈસા he is also admitting, sir, and documents were executed, and that property has been attached first provisionally, and thereafter it was confirmed, sir. You are being shown bank account statement number so account number so and so. Your name with Bank of India. Give the details. I have seen the subject bank account statement and have signed in token of having seen. I have to submit that credit of 5 lakhs on 8/10/2008 in subject account was received by check from NRO account of my wife with Bank of India. Out of this, 2,90,000 on 15/10/2008 was transferred from this account to my another bank account with Kotak Mahindra Bank. Apart from this, an amount of 2,10,000 was also transferred from this account to some bank, some account of my maternal aunt, Mrs. Vinod Mehra, residing in Gura. So far as I remember, this amount was paid toward our loan payment as the same was borrowed for making payment to my defense lawyer in Supreme Court. પછી you are being shown statement of bank account number so and so in your name with State Bank of India satellite branch. In that account, there is a credit entry 27/9/2013 of 1,37,800. Explain the source of that. I have seen statement of the bank account and signed the relevant page in token of having seen the same. So far, as I remember, this amount was received on account of disposal of shareholding with Mr. Stockbroking Corporation of India as the demat account with them was closed. પછી આ સાહેબ next question very very important. ગુરનામ સિંહ જુનેજા એનું સ્ટેટમેન્ટ રેકોર્ડ થયું છે પણ he was not examined because he was not available, sir. Whether you know any person by name Gurnam Rajinder Singh Juneja, and if you have entered into any dealing with him with regard to any immovable property, if so, give the detail. I know Gurnam Singh Juneja from Ludhiana and he is my close friend. I have not dealt with him regarding any immovable property. However, when my wife was in need of finance somewhere in the year of 2011, he helped me by way of transferring USD 50,000 from his US account to the US account of my wife. I would like to further add that this amount has been repaid back to the best of my knowledge to Gurnam Singh and his family when they were in US. However, you are being shown the copy of the account statement of Bank of bank account in the name of Srimati Shamal Sharma, Shamal Pradeep Sharma with ICICI Bank, JMC House Branch, Ahmedabad. Give the details of debit and credit entries in the said bank account. I have seen the subject bank account statement and have signed the same in token of having seen. I have to submit that the said account is saving account in my wife and the debit entry reflected therein on 3/9/2004 of 3,49,000 of 1,50,000 is the amount contributed by her toward the purchase of flat at Bageshwari apartment, Ahmedabad in my name, and the receipt of amount was informed to the department. Now, next question. You are being shown the statement account number so and so in your name with Kotak Mahindra Bank. In this account, there is a debit entry of 1 lakh on 2/4/2009. Mark narration to clear BOB card. Please explain. I have seen the statement and have signed the relevant page with my having seen the entry. I state that I do not have any bank account with Bank of Baroda, neither in 2009 nor at present. I have to check the said debit entries and will confirm the same within 15 days. Next question. In the aforesaid bank account of Kotak Mahindra Bank, there is a debit entry of 2,20,500 on 3/6/2009. Mark narration as Ketani Tra and credit of 2,058,759 by check on 4/5/2000. Give the details of this entry. I have seen these entries and have signed the relevant pages in token of saying I have to submit that the debit entry of 2,02,500 was toward the payment of some construction material to Ketani Traders regarding credit of 2,058,759 on 4/5/2009. I do not remember the source of this credit. I have to check the record and will confirm the same on 15th. However, this is very important. Whether you have sent any remittance outside India at any time for any nature of work, if so, please give the detail. No, I have neither sent nor received any remittance outside India or in India at any point of time. This is the first actually denied. Next, sir. A demat account statement, it has no actually relevance with the case. Here, આ સ્ટેટમેન્ટ ની અંદર છે along with the statement that bank statements were shown to him, he has signed and admitted and explained the entries. Now, next statement was recorded on 10th September 2015, sir. Exhibit 72. Emma, sir. Emma, question number 2, sir. Next, second page. In your statement dated 10/1/2013, you are mentioning answer number 3 to question number 3 that you would submit the exact date and other details to progress for producing, namely Bhagyasri opposite on the public satellite Ahmedabad, wherein you have for this submit that the clarity is not, then why? I state that I have been unable to provide the details till date in this regard. I state that after going through my statement today in various answers, I have stated that I would provide the details what as my house was raided and sealed twice by Office of CID Crime, and all my personal files and he did not have any details regarding that. Now, third, sir, you had stated in answer to question to the statement dated 10/1/2013 to submit the details in regard to having plot 250 square meter at Gandhinagar, 1.75 acres agricultural land at the village Nana Moara, Dehgaam, and 1.6 acre land in Dehgaam, whether you provide details, એમાં પણ એમને સેમ આન્સર આપે છે. Question number 4. In your statement dated 27/2013, you have stated in answer number 2 to question number 2 that you will inquire in regard to investment of 1,50,000 by your wife, Srimati Shamal Sharma, in Messrs Value Packaging, and in your answer number 7 to question number 7, you are also stated to provide me details of the bank details in name of your wife, single or jointly, in India and abroad. Please comment on this. This regard, I state that in regard to investment of 1.5 lakhs in value packaging, I am not in a position known how of the details of the investment and when made. Please, question number 5, sir. Page number 6. Please mention the details of movable, immovable properties and details of the bank account, either in your name, single, jointly, or in the name of your family members in India and abroad. એમાં સાહેબ એમને ટોટલ 8 બેંકના ડિટેલ્સ આપ્યા છે. એમના વાઇફના 2 એકાઉન્ટ આપ્યા છે. I state that my wife lives in the USA for the last 23 years and is a citizen of USA. Question number 6. Emma sir, please provide the source of funds for above mentioned properties and also clarify derive the property mentioned by you in answer number 5 of question number 5. Do you have any property either in your name, singly or jointly, or in the name of family members in India or abroad? For my Gandhinagar house, the plot was allotted to me by the state government for an amount of 2.16 lakh, which was paid from my personal account of either Kotak Bank or Bank of Baroda in December 2007. I will, however, confirm the same. As far as the agricultural land at Dehgaam is concerned, all the plot at measuring 1.70 acre came to me as an inheritance given by my father after he he deceased in March 2000. As far as the second land, head measuring 1.6 crore is concerned, the same belonged to distant relatives of my wife and was purchased by me for the amount of rupees 2,80,000 lakh to be confirmed. This amount was paid by me after receiving the same from my wife's account. The payment was probably done from my Kotak. This property has been actually attached also, sir, and confirmation has been also taken. He admit